Tonight's discussion in a session being held with Dr. Carla Hayden, the Librarian of Congress, on June 5th at the Library of Congress, concludes the Aspen Y Fellows 10th anniversary season. In those 10 years, the Fellows have grown to about 250 members and have had discussions with world leaders from every walk of life on this picturesque Y River campus. This year alone, the Fellows have heard from the German ambassador to the United States, America's former ambassador to Afghanistan, Iraq, and the United Nations, a Peabody Award-winning broadcaster and author, CBS's chief congressional correspondent, and a leading military strategist. The Aspen Y Fellows program is one the Aspen Institute's great values, filled with dialogue with distinguished speakers, field trips to Washington, concerts here at the Y River campus, and participation in Washington-based Aspen events. So congratulations to all you Aspen Y Fellows, and thank you for your support of the Aspen Institute. I'm Meryl Chertoff, Director of the Justice and Society Program at the Aspen Institute, and I'm delighted to welcome to Aspen the Honorable Ruth Bader Ginsburg, the notorious RBG, a Supreme Court Justice who is also an internet sensation. Justice Ginsburg is going to be interviewed this afternoon by Elliot Gerson, a Vice President of the Aspen Institute. The Justice and Society program, which is my program, is one of the public policy programs here at Y, and actually our public policy directors just concluded our own retreat next door at the River House. Justice and Society program is one of the oldest programs of the Institute. For 40 years, we've conducted conversations on what makes a just society. Our program was co-founded by Justice Harry Blackmun, and we lead annual seminars at Aspen, which are conducted by distinguished jurists and law professors. This year, Dean Robert Post of Yale and Brett Kavanaugh, a judge of the D.C. Circuit Court of Appeals, will lead our summer program. This year also, we're delighted that at Aspen, we will have the inaugural Sandra Day O'Connor conversation in honor of Aspen Institute lifetime trustee Sandra Day O'Connor. Our speaker will be a colleague of Justice Ginsburg, Elena Kagan, and also on the program, we're going to have the former Chief Justice of Massachusetts and the former Chief Justice of Arizona, both women, so in other words, an all-chick program, that has shown how far women have come on the bench and the bar. And this is in no small part due to the determination and idealism of Ruth Bader from Brooklyn, who from her early days at Columbia and the ACLU Women's Rights Project has been a tireless and strategic advocate for women's equality and for human flourishing. So please join me in welcoming to the Y River campus, Honorable Ruth Bader Ginsburg.
Welcome to the Aspen Institute home on the Chesapeake. It is a great privilege for all of us to be with you today. I'm delighted to see some friends from Y Fellows and some new faces here. And of course, as I could just see from the reaction, our guest today really needs no introduction. I will be very brief, saying a few words about her before I begin a conversation, and I hope very much that that conversation can include Aspen style as many of you as possible. So do please be thinking of questions that you might like to ask. Obviously, you can ask anything except you can't ask questions about cases that might be coming before the court. I mean, you can ask them, she won't answer them. But again, we are so pleased. You heard from Meryl, of course, that our guest was born in Brooklyn, actually in a working class, multi-ethnic neighborhood. It's important to say these things today because my children who live in New York now tell me, of course, that Brooklyn is much more chic and expensive than Manhattan. And she was educated in the New York public schools. And of course, she became the second woman on the Supreme Court of the United States. before she became a judge on the United States Court of Appeals in Washington. Actually, upon the death of a judge I had been clerking for, she had an enormously distinguished career as a professor and as a brilliant litigator, especially in the area of women's rights. She argued 6 of the most significant cases involving sex discrimination before the court, winning all but one of those cases, and she has been very aptly called the Thurgood Marshall of the women's movement. She was nominated to the Supreme Court by Bill Clinton, as you heard, in 1993 to fill the seat of Justice Byron White. And what I thought I'd do is simply read a brief excerpt from what Bill Clinton said in the Rose Garden on that day to introduce Ruth Bader Ginsburg to the United States. Quite simply, what's in her record speaks volumes about what is in her heart. Throughout her life, she has repeatedly stood for the individual, the person less well off, the outsider in society, and has given those people greater hope by telling them that they have a place in our legal system, by giving them a sense that the Constitution and the laws protect all the American people, not simply the powerful. She, of course, now, as I could tell by your applause, is a bit of a rock star, though she might prefer being called an opera star. There, of course, is the comic opera, Scalia Ginsburg, which she just told me before is going to be performed at Glimmerglass this summer. She is, of course, the notorious RBG, inspired by the notorious B.I.G., a fellow Brooklyn rapper. We have now RBG mugs, RBG T-shirts. I understand there's an RBG tattoo. Maybe one of you has it. And then perhaps, I mean, incredibly exciting, I think, is that Natalie Portman is about to play her in a movie. And the movie would be coming a little sooner than otherwise, but Justice Ginsburg just told me it was delayed a bit because Natalie Portman was pregnant. So obviously she's not playing Justice Ginsburg when she was pregnant. But I think most exciting to me is I read that there is a 3- and 4-year-old class in a Dallas Hebrew school that named the class Fish, Ruth Bader Ginsburg. So I don't know what else is possible, all of that. But all right, let's begin. So let me just ask, so would you have preferred to be an opera star?
If I had any talent God could give me, I would be a great diva. But as sad for me, I am a monotone. So I sing in only 2 places. One is the shower, and the other is my dreams. But I had the fantastic good fortune to be cast in an opera. I've been in supers a couple of times. But The Daughter of the Regiment, put on by the Washington National Opera this fall, has a speaking part. So I was the Duchess of Krakentop for opening night. There's only one problem about that. It was the Saturday following the election, and I wrote my own lines, and they were all about valorous women. So I had to.
Well, I was there, and it was very special. But, you know, I can seriously ask a question, or one could seriously have asked you as a young woman if you aspired to be an opera singer. But no sensible person, when you were a young woman, would have probably asked you if you could aspire to be a judge, to say nothing of a justice of the Supreme Court. And when you just think of, in your lifetime, how women and the law, just how radically different circumstances are, it's now possible to ask, like the young woman in the front row, would you like to be a justice of the Supreme Court? But just tell us a little bit about, and your book, the book, by the way, is absolutely wonderful. It is, and it looks like it's already sold out, so you'll have to get it on Amazon. But it's a fascinating combination of writings, speeches, dissents, even an 8th grade editorial that she wrote, which shows what was to follow. So it's a great read, and it's a wonderful introduction to how the Supreme Court works for people. But a good part of the book talks about just what it was like as a young woman in law school and looking to a career in the law. Just tell us a little bit about that and how much things have changed.
We could start with my entering class at Harvard Law School. I attended from 56 to 58, and then transferred to Columbia for my last year. There were 9 women in a class of over 500. And they divided us into 4 sections, so there were 2 women in my section. There were some inconveniences at the time. The law school in those days had 2 teaching buildings. One was Langdale, and the other was Austin. And only one of them had a women's bathroom. These were pre-Title VII days, so employers were upfront about not wanting to hire women. When I transferred to Columbia, a very outstanding law professor, Jerry Gunther, was in charge of clerkships. And although my grades were very good, he didn't get a positive response from any of the judges in the Eastern District, which is Brooklyn, or the Southern District, New York. So he approached one judge, Judge Palmieri, and said, I'd like you to take a chance on Ruth Ginsburg. Judge Palmieri's answer was, well, I've had a woman clerk, but Ruth Ginsburg has a 4-year-old daughter, and I can't take a risk on having a mother as a law clerk. So then there was a carrot, and Professor Gunther said, give her a chance, and if she doesn't work out, there's a young man in her class who's at a downtown firm, and he will come in and take over. That was the carrot. And there was a stick. And the stick was, if you don't give her a chance, I will never recommend another Columbia student to you.
Whoa.
And so that's, getting the first job was hard for women of my vintage. But once you got the first job, you did it at least as well as the men, and so the next step was not as hard. Sandra Day O'Connor graduated from law school a few years before I did, with very good grades, and no one wanted to hire her as a lawyer. So she volunteered to work free for a county attorney and said, after the 4 months, I'll work free for 4 months, and after that, you decide if I'm worth putting on the payroll, which of course she was. But life is strange. You never know what you may think that something not good has happened, like not being able to get a job. And it turns out to be remarkably lucky. So Sandra said, where would the two of us be if there had been no discrimination? Well, today we'd be retired partners from a large law firm.
Well, I don't think that means we should be celebrating discrimination.
No, but the other story about Harvard, Dean Griswold, who was a very fine dean and later a very fine Solicitor General, but he was not noted for his sense of humor. He had a dinner for the women in the first-year class, and he invited a faculty member to be our escort. So mine was Professor Herbert Wexler, who was visiting Harvard from Columbia. Dinner was not distinguished, and there was no wine because Griswold didn't drink. And then after dinner, we went to his living room. Chairs were arranged in a semicircle, and he asked each of us to tell him what we were doing at the Harvard Law School, occupying a seat that could be held by a man. Now, some people thought that was offensive, but Dean Griswold had been instrumental in getting the Harvard Law School to admit women. 50-51 was the first year that women were admitted. And he said he asked us that question because he wanted to be armed with stories about what the women were going to do with their Harvard degree. There were still doubting Thomases on the faculty. So he wanted them to know that the women would be good lawyers. I didn't know this till many, many years later, that was his purpose in asking the questions.
Let me stay on the subject of women's rights for a minute, because that was such an important part of your career, and it's been an important part of your jurisprudence in the Supreme Court. You spent many years devoted to the passage of the Equal Rights Amendment, and it came close, but it didn't pass.
It missed 3 states, by 3 states.
By 3 states. Do you think that would make any difference today? Do you think that's still a good idea?
Yes, I think it's a fine idea. Not that we haven't come almost as far as we would with the ERA by the court's interpretation of the 14th Amendment. But still, if you are trying to decide cases the way the framers would have decided them, if you ask anyone who was in Congress at the time the 14th Amendment was sent to the state, does this mean that women will be citizens of equal stature to men? The answer would be, of course not. Many states still didn't have married women's property acts. So women who married couldn't sue or be sued in their own name, they couldn't contract in their own name, couldn't hold property in their own name. The 14th Amendment wasn't meant to change any of that. But the equality principle, which, by the way, you know is not in the original Constitution, the Equal Protection Clause shows up in the 14th Amendment, which is a restriction on what states can do. When, at the time of the Brown v. Board decision, one of the cases that was combined in that litigation was from D.C., challenging the segregated public schools in our nation's capital. Well, D.C. is not a state, and it is governed by federal law. So what was the Supreme Court going to do? It was basing the Kansas case and the others on the 14th Amendment, on the Equal Protection Clause. Well, the court incorporated an equality principle into the due process clause of the Fifth Amendment, which governs. But I suppose the best reason is if you look at any constitution that has been written since 1950, you will find in it a statement that men and women are equal before the law. So I have 3 granddaughters. I would like to be able to take out my pocket constitution and say that the equal citizenship stature of men and women is a fundamental tenet of our society, like free speech, the women's equal right to do whatever her talent and hard work enable her to do. I like that to be in the Constitution for that reason.
Let me ask another question relating to women's rights. You spent much time focused on the importance of reproductive rights for women. You've also written that the law is something like a pendulum. Are you concerned that maybe in some respects the pendulum could be actually swinging backwards when you think, for example, of the restrictions on women's ability, for example, to access abortions in many states now, where it's almost impossible in many states. They have to travel, they can't afford to. Or are you concerned about possibly the law actually moving backwards in some of the things that you fought so hard for?
Yes, but not for women like me, or most of you. And not because I'm well past childbearing age, but because if truth be told, there is no woman of means in the United States who will not be able to get a safe abortion if she wants one. All of the restrictions that we see in states like Texas operate only against poor women. In the Texas case we had a couple of years ago, it was obvious that the clinic in Dallas would stay in Houston, but the people who were far from the big cities and couldn't afford to take a day off from work, the restrictive abortion laws operate against poor women, and that's the sad story. We will never go back to the way it was before Roe v. Wade because there are a number of states. At the time of Roe v. Wade, there were 4 states that provided abortion in the first trimester, no questions asked. Alaska, Hawaii, New York, California. Those states will not go back to the way it was. So it is a sad reality that any attempt to restrict abortion is going to affect only the poorest segment of the population.
And now there are even suggestions that perhaps Medicaid funding for even contraception could be restricted. Could you imagine that theoretically as an equal protection problem if contraception itself was precluded under Medicaid?
I had always thought that Roe v. Wade was put under the wrong heading. It should not have been due process. It should have been equal protection. The woman's right to choose for herself, to determine her life's course, her own destiny.
Let me ask a different kind of question. In this book, you favorably quote Judge Rubin, I think it was, for saying why it is important for women to be judges, that they bring differences in biology, cultural impact, and experience. Do you believe that women judge differently from men?
The answer that Justice O'Connor gave and that I've given many times comes from a judge on the Minnesota Supreme Court, Jean Coyne. She said, at the end of the day, a wise old man and a wise old woman will reach the same judgment. And that is so. But we also bring to the table experience that the men don't have because we've grown up female. So it doesn't make, I can't point to any case where I can say that I voted in some way and a man wouldn't vote the same way. But we do have something to contribute in. I'll give you one example. Some years ago, the court had a case of a 13-year-old girl in the 8th grade who was said to, suspected of having contraband. Well, it turned out that what she had was 2 Advil pills, but she was hauled off to the restroom and strip searched. Her mother was outraged and began a suit against the school district for humiliating her child in that way. When the argument was made at the court, some of my colleagues made light of it, talked about the boys in the gym, the 8th grade boys who were not at all embarrassed by undressing in front of each other. And I said, a 13-year-old girl is not like a 13-year-old boy. And they began to think about their own daughters. And suddenly there was no more fun and games.
You've said many times, I think, that the ideal number of women to sit on the U.S. Supreme Court is 9.
No, the question was...
Is that still your view?
The question was, when will there be enough? Well, there'll be enough when there are no more seats. We're doing pretty well now with 1/3 of the court. Not as well as Canada. They have 4 members are women, including their Chief Justice. But certainly the change has been enormous. When I went to law school, there was only one woman who had ever been on a federal court of appeals, and that was Florence Allen from Ohio. She retired before I graduated from law school, and then there were none again until President Johnson appointed Shirley Hufstetler to the Ninth Circuit. And then President Carter made her the first ever Secretary of Education. There were none again. The person who deserves tremendous credit for changing that situation is Jimmy Carter. He had only 4 years in office, no vacancy on the Supreme Court, but he literally changed the complexion of the U.S. judiciary. He looked around, he said, they all look like me. But that's not how the people of the great United States look. So he was determined to appoint women in numbers, members of minority groups in numbers, not just as one-at-a-time curiosity. He appointed over 25 women to the trial bench, to federal district courts, and 11 to courts of appeals. And I was one of the lucky 11, but I never thought about the possibility of a judicial career until Carter became president.
Much has been written, including an opera, about your relationship with Justice Scalia. And I think it's just remarkable to many people how you could have such a close relationship with a man whose views on so many things that you both were so passionate about were so divergent. You know, whether it's campaign finance, employment discrimination, affirmative action, access to abortions and contraception, Second Amendment, death penalty, yet you were very close to him. Can you help us understand how that happened? And maybe even more importantly, is there a lesson there from the collegiality you had with him that could perhaps be applied to our awful state of politics today, where people who have those divergent views seem to live on different planets and just sort of spit venom at each other as opposed to actually be friends, comrades, and associates? So first, the question, how is it that you and Justice Scalia were so close? And then secondly, is there a broader lesson for that?
We were close on the D.C. Circuit. In fact...
Here, let me help you with that.
I was very close to Robert Bork and Scalia. We used to spend New Year's together. I said, number one reason why I loved Justice Scalia so is he made me laugh. He's a very funny fellow. Beyond that, we share a love of opera. We were supers together at the Washington National Opera twice. And we both care about family. Although Scalia and I disagreed on some very important issues, he would sometimes call me. He didn't send a memo to the rest of the court, but said, "Ruth, you made a grammatical error." Or I would tell him, "This opinion is so overheated. You'd be more persuasive if you tone it down." He never listened to that. Or another one case where we strongly disagreed was the Virginia Military Institute case.
A great sexual discrimination case.
Yeah. But it's interesting, the change in the times. The title of that case is United States against Virginia. So it was the United States telling the state of Virginia, you cannot give an opportunity to one gender and not to the other. Well, it was coming about this time of year. I had circulated my opinion for the court, and Justice Scalia came to my chambers and threw down a sheaf of paper and said, "Ruth, this is my penultimate draft of the dissent in the VMI case. It's not quite ready to be circulated to the court, but I want to give you as much time as I can to answer it." So I started to read this on the plane to Albany. I was going to the Second Circuit Judicial Conference. It absolutely ruined my weekend. But then I was glad to have the extra days to answer him.
So are there lessons? I mean, just the fact that you could be so collegial that, could be applied to, say, Congress, where the very idea of being that close to someone on the other side is seemingly now so alien.
That's now. It hasn't always been that way. I was tremendously lucky to be nominated for my good job in 1993. The vote was 96-3.
And it was unanimous in the committee.
Yes, and for Scalia, who was certainly a known quantity when he was nominated for the Supreme Court, he had written a lot. He had been a judge for some years on the D.C. Circuit. There were no negative votes. And at the hearing, my biggest supporter was not Joe Biden, who was the chair of the Judiciary Committee then, although he was certainly good to me. It was Orrin Hatch.
So what has happened? I mean, you just look at the experience with Merrick Garland, and then you look at the vote for Neil Gorsuch, and as you said, it was 96-3 for you. I mean, for Justice Gorsuch, they had to execute the nuclear option. Judge Garland never even got a hearing on purely partisan grounds. So what has happened? How bad is that in terms of suggesting that the Supreme Court is just another political branch? And what, if anything, can we do about it?
There will be someday people from both sides, Republicans and Democrats, who really care about our nation. There was a group that got together on the nomination of judges for a while. I mean, the Senate used to be known as a gentleman's club. We don't set a good model for the world.
No, certainly not.
But let me give you this Scalia Ginsburg comic opera is very much about collegiality. So Scalia is locked in a dark room being punished for excessive dissenting. And I enter the scene through a glass ceiling to help him go through the trials that he needs to go through to get out of the dark room. And then a character left over from Don Giovanni, the commentatore, said, "Why do you want to help him? He's your enemy." I said, I sing, "He's not my enemy. He's my friend." And then we have a wonderful duet that is titled, "We Are Different, We Are One." One in our reverence for the Constitution and how deeply we care about the institution we serve.
Well, I think we all wish that we saw more of that from all three branches of government. You became quite famous for your dissents. There's been a long period of time where you're the most senior of the four more liberal members of the court. There was a time, I think about 10 or 11 years ago, when Linda Greenhouse of the New York Times wrote an article on the front page of the New York Times where she said that that term will be remembered as when you found your voice. And I think it was probably either the Ledbetter case or maybe the VMI case. But explain, and a bench dissent is when a justice of the Supreme Court actually reads from the dissent, when the court is announcing its decision.
A summary.
From some of it. When you do that, who is your audience? Obviously, the majority already disagreed with you. Are you speaking to the future? Are you speaking to Congress? Are you assuming that, like the great dissents of Justices Holmes and Brandeis, that the day will come when your dissent will be the law of the land? What leads you to want to read a dissent like that?
I will announce a dissent from the bench if I think that the court not only got it wrong, but egregiously wrong. And sometimes those dissents are addressed to Congress, as was true in the Lilly Ledbetter case. The bottom line of my dissent in that case was the ball is now in Congress's court to correct the error into which the court has fallen. And in very short order, Congress, with overwhelming majorities, amended Title VII so that it said with unmistakable clarity what I thought it meant all along. It reminded me of an earlier incident when the Supreme Court in the 70s said discrimination on the basis of pregnancy is not discrimination on the basis of sex. Again, there was a coalition, and by a large majority, Congress passed the Pregnancy Discrimination Act, which is the soul of simplicity. It simply says, discrimination on the basis of pregnancy is discrimination on the basis of sex. And in Lilly Ledbetter's case, well, every woman of a certain age knows what she experienced. That is, she was an area manager at a Goodrich tire plant. She, when she was hired, was the only woman area manager. One day, when she'd been working there over a dozen years, someone put a slip of paper in her mailbox. It had a series of numbers. The numbers were the salaries of all of the area managers. And Lilly could see that the young man she had recently trained was earning more money than she was. So she said, enough, I'm going to sue. She got a substantial jury verdict, and then when her case came to the court, they said she sued too late. Title VII says you must complain within 180 days of the discriminatory incident. Lilly Ledbetter is way out of time. She waited years to sue. My theory was that every time she got a paycheck, the paycheck incorporated the discrimination, so she could sue 180 days from any paycheck. I also pointed out that what would have happened had Lilly Ledbetter sued early on. No doubt the defense would have been, it has nothing to do with Lilly being a woman. She just doesn't do the job as well. But then she works there year after year and she gets good performance ratings. That defense is no longer available. They can't say she doesn't do the job as well as the men when they rated her as high or higher than the men. So now she has a winning case. But the court said she waited too long. So that kind of dissent, if the court is interpreting a statute like Title VII, then Congress can fix it. But when the court is making a ruling on a constitutional matter, Congress can't fix it. Only an amendment to the Constitution, and we have a Constitution that's powerfully hard to amend, or the court has to change its mind. But there has been a tradition in the United States of dissents becoming the law of the land. And we can go back to the worst decision the Supreme Court ever made. It was in the Dred Scott case. There was a fine dissent by Justice Curtis in that case. Or the first Justice, John Marshall Harlan, who dissented in the so-called civil rights cases in 1886 and in Plessy against Ferguson. Or you mentioned Holmes and Brandeis around the time of World War I. Those free speeches cases today are all the law of the land. So you're writing for a future age, and your hope is that with time, the court will see it the way you do.
And it often has, and I'm sure it will. I like to think of it that those dissents of yours will be the law of the land someday. A few years ago, Justice Ginsburg, you caused a bit of controversy when you suggested that the U.S. Constitution might not be the ideal model for newly emerging democracies, and you pointed to South Africa's constitution and some others, I think. Could you tell us a little bit about what you meant?
Our Constitution was written in 1787. It's a remarkable document, but it was skimpy about rights. And the reason was that many of the framers of the Constitution thought in the natural rights mode. There was resistance to having a Bill of Rights because the fear was if we write down the rights, then we'll be limiting them. People have rights by virtue of being human, and it doesn't have to be written down in the Constitution. That was the thinking then. And that's why the original Constitution doesn't have a free speech protection, a freedom of religion protection. But for today's world, the reason I cited the South Africa Constitution is they put all the basic human rights up front. That's Article 1. And then the next article is about the structure of the government. So the perception is the government exists to implement and preserve the rights that are guaranteed in the beginning.
Can you tell us anything yet about what it's like to work with Justice Gorsuch?
He is, number one, extraordinarily diligent. He was confirmed, and 1 week later, he was on the bench to hear arguments in 13 cases. And somehow he was well prepared in all of them. I had the pleasant experience of being with Justice Gorsuch 2 years ago in London when we had an exchange with judges from the UK. And we had divided up the group to various topics. I was in a group with Justice Gorsuch, and he wielded the laboring oar in the paper that we presented on access to justice. So he will be a very good colleague. I imagine that when you compare how I vote and he votes, it will be just the same as it was if you compared me to Justice Scalia.
I'm just going to ask one question, and although I could go on for hours here, it's such a privilege to be here with you. But I'm just remind you, if you have questions, what we're going to do is we're going to have 2 microphones on either side, so you're going to need to actually, we're not going to be able to come to your seat, so you might want to think about moving to one of the aisles. Where are they going to be? Cindy, one's going to be over there, and Judy, one over here. So just be thinking about that. And when Justice Stevens retired at age 90, I think, you became the oldest justice of the court. and said he was your new model, and that you would continue, quote, as long as I can do the job full steam. And we all see full steam. And we just wonder, I've read that you work out in the gym in the Supreme Court. You watch news, I hear, while on an elliptical. I understand you can do more push-ups than I think I can. And I wonder what other secrets you might share with us about this incredible stamina that we all hope has no limits to it.
It won't be a secret for long, because my personal trainer, who has been with me since 1999, has been commissioned to write a book about my exercise routine.
Well, that's going to be a bestseller.
I use there's now, it wasn't when you were clerking at the court, it wasn't there, but they turned the nurses' station, part of it, into a gym.
Now, I remember the highest court on the land, the basketball court.
But no. This is a small gym, but it has everything that I need. We meet twice a week at 7. The reason 7 is because that's when the news hour is. But I started with my personal trainer in 1999, because that was the year that I had colorectal cancer, and I had massive surgery, chemotherapy, daily radiation for 6 weeks. When I was finished with all that, my husband said, "You look like a survivor of a concentration camp. You've got to do something to build yourself up." And so that's when I started training. And now my training is also used by Justice Kagan and Justice Breyer.
Well, we look forward to the book. So again, I could keep going, but do we have people ready with questions? And if you could just please give us your name and then just a short question, preferably with a question mark at the end of it.
My name is Tom Hill, and I live in Easton, Maryland. And I'd like to thank you for coming here today and taking your time and sharing your thoughts with us, and also for your service, your many years of service to our country. Thank you, Justice Ginsburg.
Thank you.
And I guess my question is twofold. And I don't understand very much about the Supreme Court, but I'm most curious. Do you ever, as a justice, do you lobby one another? And that's the first question. And the second question is, have you ever successfully, or did you ever successfully lobby Justice Scalia? And did he ever successfully lobby you?
I wouldn't describe it as lobbying, because there's absolutely no horse trading going on at the court. It never happens that you walk into a colleague's chambers and say, "If you vote for me in this case, I'll vote with you in that case." That just never happens. But we are constantly trying to persuade each other. First, at the conference, when the court sits, it will sit Monday, Tuesday, Wednesday, meet Wednesday afternoon to discuss Monday's cases, Friday morning to discuss Tuesday, Wednesday's cases. Each of us goes around, we go around the table, each of us has his or her say. Then, if we gone on too long, the chief or one of the justices will say, "Enough." It will all come out in the writing. And then when the writing comes and you're circulating an opinion, if the court is divided and you are on the dissent side, you're always hoping your dissent will be so persuasive that you will pick up the votes necessary to make it a majority. it seldom happens, but I'll give you one wonderful illustration. Some years ago, I was assigned by Justice Stevens to write a dissent just for the two of us. In the fullness of time, that decision was announced 6-3, but the 2 had swelled to 6. Because people, when they read the dissent, thought about it and decided that I had it right. So it's important to listen to your colleagues. I do that even when there are 4 of us united in dissent. It was one case I can remember that we spent 3 hours getting together on how the decision would unfold, so there would be 1 dissent and not 4. So it wouldn't be a repeat of Bush v. Gore, where there was no time. We took the case Saturday, briefs filed Sunday, oral argument Monday, decision out Tuesday. So each of us had written a dissent. If we had had more time, there would have been 1 dissent, not 4.
Is there one?
Hi, my name is Avia Doherty. My question is, what was your hardest debate?
What was my hardest debate? Well, the hardest cases for me, they're not necessarily the most complicated legally, are death penalty cases. So those are the cases that I find most trying to be part of, to be the last step between life and death. I'd like to say on that there has been a precipitous decline in the implementation of the death penalty in the United States. So last year there were only about 6 states. Many more have death penalty on the books, but they don't use it. 6 states, and even within those states, there are variations from county to county. So it may be that it will end by attrition.
Hi,
Please.
question. Hi, it's Lynn McGrath. And first, I just want to thank you for the profound impact you've had on the rights for women. So grateful. The question I have, and I'm a scientist, I'm not a lawyer, and I hear a lot about the shifting of the balance of the court and the political will to change the balance of the court. And I'm not sure what that actually means and if I should be nervous about some of the protections that we've had over the years. So I'm just wondering what your thoughts are, and do you have any concerns about this shifting the balance of the court with new judges potentially going on the court in the next few years?
No. Presidents have been disappointed in some of their choices. Maybe Earl Warren is the most outstanding example. He was a tough prosecutor, Republican governor of California. He became the Chief Justice, and the court did some brave things, not just in ending apartheid in America, but in the criminal justice system. Justice Brennan was a Republican. He was a member of the Supreme Court of New Jersey, and he was thought to be a good middle-of-the-road type. Justice John Paul Stevens, in my tenure on the court, Justice John Paul Stevens and David Souter, both Republicans. Stevens appointed by President Ford, and Souter was appointed by was Bush.
President Bush. First Bush.
And I guess if you would rank the court, who were the most liberal justices, they would turn out to be Stevens and Souter. So, and I think two of my old Chief Justice Rehnquist, in the 70s when I was arguing cases, I could count on him to be in dissent. The chief had criticized the Miranda decisions, the Miranda warnings that you have to give someone who is arrested. He'd criticized it many times. Then we had a case where the question was, should Miranda be overruled? And the chief wrote an opinion saying no. It has become part of the culture that the police have to tell you, you have a right to remain silent. If you speak, whatever you say can be used against you. You have a right to have a lawyer, and if you can't pay for one, the state will provide one. Those, the chief said, have become part of our culture, and it's working. Or, a huge surprise to me, he was on my side in the VMI case. Mm-hmm. Or the most startling was the Family Medical and Leave Act. That was attacked as beyond the powers of Congress. The Family Medical Leave Act was written with a woman worker in mind. What would she need to be able to function successfully? She need time to take off to care for a sick child, a sick spouse, an elderly parent, if she herself became sick. Chief Justice Rehnquist wrote the opinion upholding the Family and Medical Leave Act. And when I brought it home to my husband, he said, "Ruth, did you write that opinion?" So as he lived, he learned.
Got a question over here, I think.
Yes, Justice Meryl Chertoff from the Justice and Society program. When you were at the ACLU, you and your colleagues, Harriet Rabb and the other pioneers, studied what had been done by Justice Marshall and his colleagues at the NAACP Inc. Fund. And you did both reproductive rights cases, but you also had a focus on economic rights cases, very important focus for you. The current civil rights movement which has captured the attention of the nation and has had a remarkable success is the gay rights movement, with the decision in the Obergefell case recognizing the right to same-sex marriage. If you put on your ACLU hat for a moment and were giving advice now to the strategists in the gay rights movement on what the next cases should be in civil rights litigation for that movement, what advice would you give to them?
I think that the gay rights movement also learned something from Justice Marshall. So they didn't come to the court as the first case and say, we want to have our right to marry recognized. They started with Lawrence v. Texas. Their first effort was to see that there were no more laws criminalizing consensual sodomy. That's how they began. And then they dealt with Colorado, the ordinance that said you can't include gay people in any anti-discrimination law. So they won that one. And then the next step was the Defense of Marriage Act that said the federal government cannot recognize. By the time of DOMA, Defense of Marriage Act, a number of states did recognize same-sex marriage. So this was about the fifth time that Obergefell was not the first case, it was the fifth case in that line. But I think we've seen a very rapid change for one reason. It used to be that gay people were, the expression was, in the closet. And you couldn't say who you were because you might not get a security clearance. When the gay rights movement, when gay pride was the motto, and people stood up and said, "This is who I am, and it's just fine." So, who were those people? Our next door neighbor, maybe? Our child's best friend? Maybe our child? There was no we, they, because we came to appreciate that they were part of we. And I think that's why the movement has been successful in short order. It was really the people were no longer hiding what they were.
Thank you. Over to this side.
Hi, my name is John Lewis. I'm the headmaster of a local private school here in Centerville, Maryland. I'm here with a couple of my colleagues. I also have the privilege of teaching one class, and that's AP Government, every year. And we always have a debate about the Constitution and judicial tenure, right? So obviously when the Constitution was written, judges' lifespans were not what they are today. And there always seems to be a really robust debate in class about whether there should be, say, a 20-year limit for Supreme Court justices. President Company excluded, of course. Grandmother clause.
Yeah, I've been there 24 years.
I don't know if that's something you have a thought about or care to comment about, but it's a question that interests my students great. So I thought I would ask it, and it's just a tremendous thrill to be here as well.
Well, how fortunate I am that the framers were wise enough to put in the Constitution that the judges shall hold their offices during good behavior. There were two protections of judicial independence written into the Constitution. One was that we hold our offices for life, if we want to stay that long. And the other is that Congress can't diminish our salaries while we are in office. So that those two protections of that we would be paid and that we would have life tenure. Many states have compulsory retirement ages, age 70, 75 is typical. Many states elect judges, and many elections are contested elections. When I go abroad, that is one of the most common questions I'm asked. They say, you take great pride in the independence of the U.S. judiciary, but how can they be independent if they have to stand for election? That's a hard question to answer. The old Chief Justice Rehnquist once said, the day a judge begins basing his or her decision on what the home crowd wants, that is the day he or she should resign from office. But it's hard to resist what the home crowd wants if you have to depend on the home crowd to keep you in office. One of Justice O'Connor's post-retirement projects has been to try to persuade states to go from elective systems for judges to appointed systems.
Yes, and she's actually spoken about that quite passionately with Aspen audiences. It's one of her really great causes. I think we have a question over here.
My name is Ben Tillman. I'm from Queenstown, Maryland. And I did a very brief and unsuccessful stint in politics, which got me thinking about the Citizens United decision I have never been able to understand it and would very much appreciate your observations on how the court came to that conclusion and what it really means. Thank you.
I can't tell you other. I can just say read the wonderful dissent. It is, and it keeps getting worse. But that's a decision that I don't think has long-term staying power.
Do we have another question here? I want to ask a different kind of question then, if someone else is going to come up. And thinking about the various talks we've had in Aspen context, and one person who spoke shortly after her famous article came out was Anne Marie Slaughter about balance, and women can't have it all. And I know when you were beginning your career, the notion of work-life balance wasn't even in the lexicon. But you've had an extraordinary career. By all accounts, you had an extraordinary marriage. You have been a successful and devoted mother. How do you think about that issue? And do you have any advice? And haven't you had it all?
Yes, but not all at the same time. That's in a good marriage, you accommodate to each other. So there were times, for example, when my husband he was determined to become a partner in his law firm in 5 years, and during that time, I would say I did the lion's share of the child care, even the cooking. but
I understand he was a great cook.
Yes, and my daughter, when she turned 15, noticed the enormous difference between Daddy's cooking and Mommy's, and decided that Mommy should be phased out of the kitchen altogether. So I've been living in D.C. now for more than 30 years. I have not cooked a meal because my daughter, having phased me out of the kitchen, comes once a month. And my husband, of course, fed me very well, but since he died, she comes once a month, spends a whole day cooking, fills the freezer with enough till she can come back the next time. But then when I was appointed to the D.C. Circuit, I was sometimes asked, isn't it hard to commute from New York to D.C.? And I said, what makes you think that I'm commuting? We're living in D.C. So Marty, who was then teaching at Columbia Law School, transferred to Georgetown Law School. So over my long life, I have had it all, but as I said, not all at one time. And I was amused by one of the things that I haven't read Anne Marie Slaughter's book, but I did read the article in the Atlantic, and she talks about when she was working very hard at the State Department and had one son who was difficult. And then when she went back to Princeton, the son's behavior notably improved. Well, I have a wonderful son, but when he was in school, he was what I call lively, but his teachers call hyperactive. It takes time. My favorite story in that regard is he was going to a private school, and I'd get called to please come down to the school to talk to the headmaster or the room teacher or the school psychologist about my son's latest escapade. One day, being particularly weary, I said to the school, this child has 2 parents. Please alternate calls. And it's his father's turn. Well, so Marty went down to the school and heard about what my son James had done. After that, the calls came barely once a term, because they were much more reluctant to call a man away from his work than a woman.
Well, ladies and gentlemen, I would like to thank you all for being here, and most of all, to thank Justice Ginsburg for giving us so much time on this assessment.